So, Council, am I understanding the point you're making? Similar to what I might have read in the regulations, that the fact that there are criminal proceedings running would not stop the internal disciplinary here.
It can't. With great respect, Malord, it can't. These actions are not interlinked to each other. They might cross over on the same factual and many issues on the same legal matters, but they're completely different. And with great respect, and I refer to that in paragraph 22 of my heads with reference to the freedom under the law matter, which I quoted there, paragraph 206 of that matter, where the Commissioner is obliged to take steps of disciplinary nature against senior officers. He has to take that. He will be abdicating his responsibility in terms of the Constitution to manage and control the police force. He will not be fulfilling the objects of the police force as is in section 2 of the 5. Think further, my lady and lords. The police are the one entity by training and experience who investigate things. Whether it is criminal activities, this is their bread and butter, if I can call that. The Commission will rely on people, for example, in the police, to present to them the facts. They can't go and look for witnesses. They're not sleuths. And for that reason, to say that parallel to the Commission, the police may not investigate these issues on this front, even with regard to the possible misconduct. How does the Commission do that, though? It is just, for me, with great respect, it is not correct. It cannot be that. Now, it is important that one should be careful that one do not try and decide who is right and wrong on the merits of the complaints and of the misconduct and or of whatever. Because this is not fully ventilated before this court. What is fully ventilated is the reasons why the Commissioner took his decision. He's explained that to the court. He's in his affidavit. Why did I take this decision? And further, this is why I took the decision, and I can categorically state that the decision was not taken in terms of the regulations. And with great respect, I have indicated to you, when I started off, that the decision just needs to be not contrary to any act or regulation. That is what the regulation says. It says it must be a lawful order that you give. And I still hold that my example that I have explained to this court is very relevant to this. Go home while I investigate. I'll deal with you later, but go home to allow me to investigate these issues. We must remember the seniority of the applicant in the office, even if he doesn't intend it to be. It's intimidating. Here is the person now all of a sudden against whom these serious remarks are made, and now I'm asking the person sitting next to you, make me a statement. Oh, I'm not going to do that. The man sees he's talking to me and he's going to ask me what I do. So whether it's intentional or not, that's irrelevant. But on the face of it, it does not allow for a transparent and accountable investigation. Then is the decision that the Commissioner of Police made and the order that he gave, is this reasonable order under the circumstances? I would say yes. Was it necessary? I would say yes, it was necessary to ensure a fair preliminary investigation. Was it reasonable under the circumstances? Yes, I would say it was reasonable. It was, in the circumstances, one would have expected him to take a strong point and to be decisive in this regard. Was it relevant? Most definitely it was relevant. It was to the point to ensure the preliminary investigation into allegations against him being investigated. Was it rational? Lord, there we must look objectively. Was it a rational decision under the circumstances? I can't fault the Commissioner for dealing with this later in the heads of arguments. And was it proportional? This was something much worse could have been done. It has got no punitive measurement to it. There's nothing that one can say the applicant has now been punished through the stay-at-home order. There's nothing. How can you punish him? So once you can take all these considerations in mind, and one think about that and one apply that to the legality of the decision, it is my respectful submission that the stay-at-home order, Exhibit SS2, can never be construed as formulating a precautionary suspension. And it is well within the powers of the National Commissioner managing his police service that he can do that. It's not an illegal order. It's not in contrast or there's no law that says he cannot do that. And the fact that this started off also with a notification of an investigation in terms of the disciplinary regulation shows that this was a process in its infant stage which would progress in terms of the disciplinary regulation, which he did. And there was then a notice, and the applicant was given the opportunity to submit a representation, which he did. I might be oversimplifying the issue, but I cannot put it in more standard. I understand it like that, and I convey it to you the way that I understand it. And my respectful submission is that it is supported not only by the facts, but it is permissible in law. I know the case law which says that an order to stay at home can be construed as being a suspension. I know that. The case law, I've read that. My learned friend has referred to that. But in this instance, where there is a clear differentiation between the stay-at-home order and the notification in terms of the regulation, it takes that order out of the realm of the disciplinary regulations. That's not only the fact that it doesn't refer to that, the Commissioner of Police is emphatic in his affidavit stating that I never intended to act in terms of the regulations when I gave that order. So, if there's any specific issue which your ladyship or lordship would like me to address, I obviously will. I appreciate actually interaction to guide an argument.
I understand the applicant's case to be that in order for you to do or instruct the stay at home, there is no other legal authority available to you other than the disciplinary regulations. Now, if the applicant is correct in that regard, submission, or at least in the paper, it is pointed out that I did not use the disciplinary regulation. Perhaps this is where the submission that you had considered to unlawfulness arises. What was or what is your power as the National Commission to stay at home? To instruct if they stay at home?
Lord, I can only refer you to the issues that I have referred you to, Section 11, to the Constitution, which obligates me to act, to Section 11 of the Police Act, which says that I must do powers and functions necessary to do that, and then to perform any legal act or act in any legal capacity on behalf of the service, and that qualified by the regulations, which says that commanders can issue instructions which are not inconsistent with the Act. And there is where I come to the situation where I say, this can never be codified. That every instruction that the police officer can give to his subordinates must be taken in subsection 2356. That empowers me to give to tell you the order to salute me, or to tell you, if I tell you to stand up straight, or to sit down. That's orders that are given in the management of the police force service. That's orders. There must be countless of orders in the police service, given by superiors to inferior or to lower ranks, which does not find its empowering legislation, but which is not contrary to the Act or the regulations. It's not unlawful, in other words, in itself. And that is my submission, that it is not an unlawful act. This is not an unlawful instruction that we get. It is similar to my firearm situation that I've referred to. Go home.
So, Counsel, then do I then understand you to be saying that you disagree with the submission that the only source of power is the regulation? Yes. There are various other powers, like the Constitution, like Section 11, like the Regulation 6. That's how I understand.
Yes, that's indeed what my submission is. And even the Constitution. Yes, the Constitution is also a basis of law.
Yes, but with the Constitution directly, you might run into the subsidiarity argument.
Indeed so, Lord, but
because there is the Empowering Act and the regulations, but you say even on the subsidiarity argument, because there are those enabling provisions that can be used for, or is used for any lawful
action, for lawful instructions.
Orders by a commander, instruction by the commissioner.
Yes. Yeah. Yes. It must. Lord, otherwise one will have to look with a thick book for everything that you need to do to find Section 6, to Bureau find it. Okay, we don't have a codified legal system. And therefore, the general principles of legality must apply. And that is what I refer your Lordship to is basically, in paragraph 29 of my head, that is basically the principles on which basis such an order would have been legal and authorized.
Just one answer. The Council for the other raising it with much force, and that is the allegation of a breach of contract. The allegation being that the disciplinary regulations form part of my employment contract. And as a result, you are bound, if you are to take any disciplinary action, you are bound contractually to have regard to the disciplinary regulation. What do you say to that argument of breach of contract?
But the law certainly, if the only argument can be that the stay-at-home order is a matter of discipline. Perhaps that is true. But it doesn't have to be discipline. This constable that has fired his shot, I'm not disciplining him by sending him home. Not at all, not by a long shot. It is the same with the applicants. I'm not disciplining him by telling him to go home. There's reasons why I'm telling him to go home. And that has got nothing to do with discipline or punishment. That is to allow me, to allow a bit of distance here. Let's get a bit of distance here so that we can operate here and that we can do what we need to do in the interest of transparency and accountability.
So in your submission, there can't even be a case for breach of contract because
it is not a disciplinary issue. The notice was a disciplinary issue, but that was done within terms of the disciplinary code regulations, and it is substantiated for me by the fact that SS2 makes no reference to the disciplinary code. I've said, I'm sorry, is there a question? No, thank you. I'm sorry, my ears with my grey hair is not as what they used to be. But thank you if that.
No questions, but what are your submissions on costs?
Oh, the lady below. With great respect, BioWatch is not a cover or protection for every person that mentioned the constitutional rights. I respect your submission in the light of the allegations that is made. They are serious allegations, which go to so many aspects in relation to this case, that I cannot believe that the applicant should be protected by for a cost order against him. And I would urge that it is a normal cost order. I see that there is indication that I asked for a special cost order. I didn't ask for a special cost order. I asked for just cost for me. Thank you.
Yes, my lady, briefly. Can I start with the Commission of Inquiry terms of reference? Because what my learned friend said is he said three things. One, they're not going to deal with employer-employee relations. Two, that they don't have the ability to be sleuths. That was his exact how are they going to investigate. And three, what powers are they going to have in terms of the delivery of their recommendations? If the court goes to 001-64, these are the terms of reference of the Commission of Inquiry, paragraph 7. It says the following: the Commission shall also consider prima facie evidence relating to the involvement of individuals currently employed within law enforcement or intelligence agencies, and, where appropriate, the Commission must make recommendations regarding the employment status of such officials, including whether they should be suspended pending the outcome of further investigation. On this notion that the Commission is not going to be dealing with employer-employee relations, that's squarely against my learned friend. That's point 1 on the terms of reference. Whilst we're there, point 2 over the page, 001-65, my learned friend says, well, how are they going to investigate? This is all an internal matter. It's about witnesses and everything else. Look at what the Commission's powers are in terms of paragraph 10 at 001-65. The Commission shall have all the powers necessary to achieve its mandate, including summon witnesses, power to conduct search and seizure, deviate from the Act insofar as it provides for public hearings, refer matters for immediate criminal investigation and urgent decisions on prosecution, taking into account the nature of the allegations and the evidence heard. So insofar as their power to do this actual investigation is concerned, the Commission's terms of inquiry tells you that that's exactly within their mandate, to perform this kind of investigation that my learned friend says is more appropriately done within the SAPS.
But there must be notionally a difference between calling a witness and saying to the witness, come tell me what happened there, bring all sorts of books you have, or even if you conduct a search. There's notionally a difference between that, as we've seen in the functioning of the Zondo Commission, to call the Commission back, and what a detective does and actively investigates and request and perform ballistic tests.
No, correct.
Obtain hard evidence,
No.
fingerprint.
Correct. But what we're talking about here is we're talking an employment type of investigation that General Masemola will be conducting. General Masemola is not doing ballistic testing. He's not doing police work vis-a-vis General Sibiya. He's doing an employer-employee type of investigation. So what I say in response to that, Justice Davis, is that that is entirely consistent with what Para 10 provides for, because that's exactly the kind of function that we say is more appropriately done by the Commission. On the last point, how long is this going to take? What are they going to do? On that same page, 001-65, just look at what it says at paragraph 12. The Commission shall, where appropriate, refer any matter for prosecution, further investigation, or convening of a separate inquiry to the appropriate law enforcement agency, government, department, or regulator. So, in other words, the idea that the Commission is not going to have the fullest powers to investigate these same allegations that General Masemola insists his disciplinary process must have jurisdiction over is squarely contradicted by the terms of the Commission itself. The Commission is going to do exactly that. And once we can establish that the Commission can achieve exactly that, that takes you then to the discretion issue under the interdict test that I argued earlier, as well as expediency vis-a-vis Gordon, both in the High Court and in the Constitutional Court.
So, Counsel, let me understand this. I'm trying to look at these terms of reference.
Yes, my Lord.
And I'm not sure whether I can pick up where the Commission will be empowered to discipline members of the South African Police.
001-64, para 7. Employment status must, with all due respect, be read to include the power to discipline, because it talks about employment status.
No, it says must make recommendations
Correct.
regarding the state.
No, correct.
So it can't of itself do anything.
Oh, yes. Well, that's right.
That is my question.
Oh, then I apologize. I reacted too quickly. But however, what I would say is that given the recommendatory power that I referred to in 12, that achieves the same outcome, because that's then the basis upon which the discipline or the disciplinary action could be implemented. But what we see occurring here is that the Commission of Inquiry, an independent Commission of Inquiry, has the powers to undertake an independent, at the very least, fact-finding investigation, which allows it as a neutral actor to make determinations and recommendations against my client. And you'll know all of the reasons that I said General Masemola is unable to do that. So,
Now, if the Commission does not have powers to discipline members of the South African Police Service, what then would happen to members of the SAPS who had committed misconduct, punishable by either the disciplinary code or any other power that the SAPS would have? What happens during the currency of the Commission?
the Commission can recommend disciplinary action be taken. But remember, that's the dispute we're having. The dispute we're having is we're saying that because of the conflict of General Masemola in making that determination of what should or shouldn't be a disciplinary issue, because of his involvement in the chain of factual causation of the underlying allegations against General Masemola, that's why the Commission is more appropriate. So on the interdictory suspension relief, we say that that's appropriate for the Commission to do rather than for General Masemola for the reasons that I've advanced.
So your answer, can I just follow?
Yes.
Your answer seems to suggest to me that if Mr. General Masemola was not implicated in the manner which you suggest, there was nothing wrong for him to institute disciplinary steps in the currency of the Commission.
Well, would it be, are we ignoring the stay-at-home order? Because if we throw the stay-at-home order in that, then I will say no. But if we exclude the stay-at-home order, then I will say, yes, that's fine, provided that there has been compliance with the regulation itself. Remember what we are saying insofar as the interdict and the suspension relief is concerned is we're asking the court to exercise a value judgment as to which the more appropriate forum would be, given the interrelationship and conflict between the parties. And the point that we're making is not for you to say that the police is somehow stripped of the power, but on these particular facts and in these particular circumstances, that it would be appropriate to let the Commission do that work rather than General Masemola. That's the point.
But on your balance of convenience argument, where you're now also, involving the value judgment, there is serious misconduct which will jeopardize the relationship between the employer and the employee, or between the commander and the second in command. And an independent disciplinary chairperson sitting in terms of the regulations finds that it is so serious that the relationship should terminate. And that's also the sanction in the disciplinary inquiry. You say, but that shouldn't take place. That possible prejudicial relationship should remain in place for 3 or 6 months or a year until the Commission is finalized, after which the Commission may make the same recommendation to the Minister, but then only will disciplinary steps then have to take place. And in the meantime, the status quo should remain.
Yes, and can I explain why? What my learned friend said was very important is that General Masemola said to General Sibiya that you will have an independent arbitrator, that an independent arbitrator will be the decision maker. So you'll remember, if it were an entirely independent process and General Masemola were not involved, then my ability to argue that General Sibiya should not be subject to those otherwise ordinary independent disciplinary process would have reduced substantially, because the entire process is clothed by a degree of independence of the people involved and who make the suspension decisions and whatever else might be the case. The difficulty we have here, however, is that we're not in that scenario, because you'll remember what happens is General Masemola is the one who says in SS1, SS2, and then SA1, these are the allegations that concern me, but in consequence of those allegations, I'm telling you to stay at home. I know there's a debate between my learned friend and I whether or not that's to preserve the investigation or not preserve the investigation, but the very fact of the matter that the stay at home as a disciplinary response in the widest of senses comes from someone who is implicated and themselves is not independent for the reasons I addressed earlier from Liebenberg and so on, demonstrates the fact that this particular disciplinary proceeding is not one that can continue in the way that it is. And I hope that I'm trying to be fair to say that if we were in the completely independent realm, then yes, the argument wouldn't succeed or it couldn't stand. But we're not there, and that's why the independence role of the Commission is where it's appropriate for it to play that role. May I move on? No, I was just on topic number 1, having engaged with Justices Davis and Justice Moshawana. Can we go very quickly to this command structure argument that has developed by my learned friend? Just a couple of things. First thing, at 073-10, which is my learned friend's heads of argument, you will see that this Regulation 6.3 that he was talking about and the consistency of Regulation 6.3, you'll see that that regulation is not about discipline. It's about orders in general, but more importantly than that, it's a regulation that comes from 1964. And why that's important is because, remember, what does General Masemola cite in SS1 and then in SA1? He only ever talks about Regulation 8.1 and 10.1, which comes from the disciplinary regulations. And if you look at General Masemola's answering affidavit, there's no reference to this particular Regulation 6.3. Where it comes from is it comes from my learned friend's heads of argument. Now, I don't criticize that, but the point is you'll know the lex specialis rule, and that is if there's a particular piece of legislation that regulates a specific topic, you apply the specific piece of regulation rather than any other or more generalized one. So to the extent there's a conflict between this regulation that my learned friend relies upon and the regulation, the disciplinary regulations that my client relies upon, we would say lex specialis applies, and that's why it's the disciplinary regulations. So that's point number one on the command structure. Point number two, I just want to refer to my learned friend's heads of argument, because what my learned friend's heads of argument at para 5.2, it's the thing that you just had. What is that? No, go back to where you were. Yeah, what's that? Oh, my learned friend relies on at paragraph 22 of his heads of argument. He relies on the freedom under law decision, and I'm not going to repeat myself. All I'm just going to say about the freedom under law decision is that the court there was emphatic that the way in which the police commissioner gives effect to his powers of management and control is through the disciplinary regs. So you can't say that just because the disciplinary regs don't give me what I want, you can go around it. That's the thing that binds you. That's my learned friend's own authority. And whilst we are on my learned friend's own authority, what I would refer the court to, which I've done already, I'm not going to repeat myself, is the SA Police Union case, which makes it clear that if there's an intersection between the commission and the police commissioner, just because the commission can adjudicate certain matters that a commissioner might otherwise do so, does not mean that that results in an unlawful usurpation of the police. And we're saying that's fine for our purposes, because what we're asking the court to do here is exercise value judgment. Can I just then deal quickly in this command and control structure with this example given by my learned friend about what happens at a crime scene and there's a shooting and then you tell him to go away and whatever the case is. Firstly, that's not what General Masemola tells you in the answering affidavit he did. He just tells you I exercised a stay-at-home decision. But the second and the more important thing is that highlights the importance to preserve something. And in fact in SA1, none of those notices, which are the instruments through which either the stay-at-home order, the allegations of misconduct, or the suspension notice, or the precursor to the suspension notice, mention the need to preserve the investigation. That only comes out in the answering affidavit. And what you know from administrative law, and this comes from the judgment of the Constitutional Court in Auricon versus City of Cape Town 2017, is that when the reasons exist at the time the decision is taken, those are the reasons against which the administrative action clock starts to run, but more importantly, that the lawfulness of the administrative action is evaluated. And what we would say is that if there is an absence of reasons contemporaneously at the time at which the administrative action is taken, it's not appropriate and actually unlawful for the decision maker to try and supplement that reason in the answering affidavit when the instrument at the time didn't mention it. Still on the command and the control structure, I just want to briefly say my learned friend made the statement a few times that we don't have a codified system of law and that not everything has to be written down. Well, with all due respect, if my learned friend's argument were to be accepted, that would flip the principles of public law on its head, because what we know the principle of public law says is as follows. It says that it entails that both the legislature, I'm reading from Affordable Medicines, para 49, it entails that both the legislature and the executive are constrained by the principle they may and perform no function beyond that conferred upon them in law. In this sense, the Constitution entrenches the principle of legality and provides the foundation for the control of public power. So in other words, you can't say that because the instrument doesn't give me the power, I'm allowed to then invent it. In fact, Affordable Medicines tells you it's the other way. Affordable Medicines tells you that if the underlying instrument doesn't expressly provide you the power that you're saying that you're enacting, then actually that's unlawful. Because that instrument, you are exercising a power that is greater than that which is conferred upon you by the instrument. So my learned friend's argument on that point regarding the codification of law and not everything is written down, with due respect, doesn't go much further in that regard.
Was there no missing of that argument? I understood the argument to say that for instance, if they rely on Regulation 6, Regulation 6 cannot say, amongst others, orders like standing, greeting your superior, and so on.
Uh-huh.
And it can say you have
Yes.
issue orders and
Yeah.
instructions.
Correct.
So out of that,
Yeah.
you will source the power to do
No.
any other thing, including standing.
No. And can I disaggregate why? Because that regulation, 6.3 quoted by my learned friend, is separate to the regulation that I've just spoken to you about, which is the disciplinary regulation. If you accept the maxim of lex specialis, then you know that where you have to look for that generic enabling instrument must come from that particular regulation. What my learned friend encourages this court to do is to read a general entitlement in an unrelated regulation, which has no standing regarding specific issues of discipline, and asks you through the back door to enable a power in the disciplinary regulations by reading those in circumstances where that regulation itself doesn't even say that you may have regard to other regulations for the purpose of discipline. So with all due respect, my learned friend's argument flips the principle of public law on its head once again.
No. I understand it to be the stay at home is not a disciplinary measure. That's where the first point. It is not a disciplinary measure. It is an instruction that is relevant, that it can be issued by the commander, even on the powers under Regulation 6. But where I think you are relying on, you want to consider the stay at home as a disciplinary measure. And he is saying, in the affair, it is not.
Yes. But, and may I just, going back to that Plascon-Evans point that we were discussing before the lunch, I think, Justice Moshawana. Obviously, on the facts, there's no dispute that as to what the Commissioner said he did. The Commissioner said he relied on 207. So on a factual version, you'll remember in the replying affidavit, we say, yes, he says he relies on 207. We accept that, but we say that his reliance on that is legally incompetent for the reasons that I've engaged. And then on the specific issue, just because the repository of the power tells you that I am entitled to act under another regulation doesn't mean that the court has to accept it even in motion proceedings, the version of the respondent. The true test that you yourself, with all due respect, looked into in paragraph 16 of Let's Waolo is about what's the source of the authority. And if we can accept that the stay-at-home order here is directly related to the Mkwanazi allegations, which they are, and the Mkwanazi allegations themselves form the basis of General Masemola's disciplinary action against General Sibiya, both in terms of Reg 8 and in terms of Reg 10, then we're placing form above substance. Because then the stay-at-home order is not a stay-at-home order at all, it's a precautionary suspension. And with all due respect, whilst I'm on that point, my learned friend said something very important about that. What he said in the argument is he said, you know, the National Commissioner has an important duty to take this action. And his exact example was, imagine Sibiya goes to the office and then he has to get an affidavit from someone sitting next to him. That's what my learned friend said. My learned friend's exact words were, he might not even intend for it, but his very presence might be intimidatory. My lord, that is a precautionary suspension factor, plain and simple. Because every time a precautionary suspension is applied, no matter what you call it, it's about, as we know from Long versus SAB, preserving the integrity of the investigation. And can I just say in that regard, my lord, the reason that our learned friends can't just invent it by the flick of a term and say it's now a stay-at-home order is, what does Reg 10 tell you? Reg 10 tells you, yes, you can place someone under precautionary suspension, which is to preserve the outcome of the investigation and preserve that process. But you have to give them the opportunity to make representations. And what do we know happened here? My learned friend said that the stay-at-home order was to achieve these things. It was to prevent these intimidatory consequences. It was to preserve the investigation. So in substance, it's a precautionary suspension, and there was no compliance with Reg 10. So respectfully, our learned friends can't have it both ways. When we say to them, well, your stay-at-home order is a disguised precautionary suspension, they argue, well, we're entitled to invent a power outside the disciplinary reg, and then we say to you, but affordable medicines controls you, and they say, well, it doesn't matter. And then on the other hand, when we say, okay, if the stay-at-home order is what it says it is, if it ticks all the boxes of a precautionary suspension and you haven't come home under Reg 10, how can it withstand legal scrutiny? And then they say, well, we don't have to comply with Reg 10. That's the very point that we made earlier about also the trial prejudice that General Sibiya is facing every time that the argument shifts when the National Commissioner is sought to be held to account. But let me...
One of the reasons why there was a stay at home was to save the applicant from an embarrassment. Do they say so?
They say so.
Yeah.
Well, you know what the response is to that. The response is that the applicant says, I'm even more greatly embarrassed by the fact that I'm being placed on a precautionary suspension on allegations which are not credible and which have no factual basis.
What I'm trying to test is this. You want to call the stay at home precautionary suspension and because the intention is to preserve the investigation. Now, if it is set out in the paper, that one of the reasons why I had to go back was to save the embarrassment. That has got nothing to it. Can't be precautionary suspension if I have to save an embarrassment. Can it be?
Well, not on the test we know from Long versus SAB, but then you have to ask yourself, how can you elevate that decision about saving embarrassment and hold that to be the predominant factor in circumstances where my learned friend was also talking about protecting investigative processes and so on. And in any event, even if that is the case, we go back to the same debate about the source of power, and your lordship knows my answer on that. So whilst I'm there, and I've dealt with the independence and I've dealt with the status of the... Can I just make this point? And my lord and I had this discussion when I referred you to the fact that the investigation has concluded based on what the National Commissioner has said. And then when you put that same question to my learned friend, you said, what is the impact of that, the status of that being completed on this? My learned friend then started answering you by saying, with all due respect, oh, well, the employment relationship has broken down and all those kinds of things. But my lord, that's not the purpose of a precautionary suspension or even a stay-at-home order, with all due respect. That illustrates, with all due respect, the schmuchel that really is evident here, is that this invented power of a stay-at-home order is being used to obtain the consequences of either a precautionary or a punitive suspension, and it's done so with no power at all. But what your lordship would obviously know is that if the investigation is concluded, and let's assume in the National Commissioner's favor it is concluded, then obviously there's no need for him to continue to be kept at home. In terms of that suspension. Yeah, he said it was concluded on 1 August, that's right. I beg your pardon?
Unless if he has already been suspended.
Which we don't know about, because remember, the only thing that comes out from the supplementary affidavit is the Reg 10 notice, which says, make your representations, and then I'll consider and I'll do something. So that really takes me back to the procedural spaghetti point I made earlier. How is it that you're keeping the man at home under a stay-at-home order, which we say is a disguised precautionary suspension? You don't comply with Reg 10 because that presupposes that your investigation is still ongoing, but under oath you've said that the investigation closed on the 1st of August, so there's a disaggregate there, there's a lawfulness problem there. But then at the same time, under Reg 8, you say here's the allegations, and instead of commencing the proceeding, you say to the person involved, stay at home, and then you exercise some kind of other power to keep them at home in circumstances where your purpose for keeping them at home is to achieve the outcome of a precautionary suspension. That's the point, my lord. So I've dealt with status. My Lord Justice Davis, I think my learned friends and my attorneys, I think they are suggesting that I need to give you some references to the record regarding the dockets. Because I think there was some confusion between myself, and I'm obviously to blame for this, about the question is what should happen and versus what actually happened. My submission on the what should happen is that, well, my client can't say anything about that whilst he's at home, but also that must be dealt with in the ordinary round of the police and their structures. In terms of what actually happened, may I just give you the following references, please? What you'll see in the founding affidavit at 001-45 from paras 170 all the way to 001-46, para 180, is General Sibiya tells you what happened with the dockets. He says that the minister instruction, which was repeated by the National Commissioner, General Sentumule received the dockets, and that was on his instruction, attempted to transfer them to KZN. I apologize. That was on Sibiya's instruction. This is what he's saying in the founding affidavit. He then says General Mkhwanazi refused. He says that contributed to the delay. And he says as a result of General Mkhwanazi, I'm not responsible for those delays. And he also goes on to say that the National Commissioner and personnel in his office advised what to do regarding those dockets, that his directorate had nothing to do with it, that they ought to have been sent to KZN, and it's unreasonable that the KZN team said no, and at the same time that funding is being withheld. The reason I mention that is because that's also all contained in Annexure SS20, which goes from 001-160 to 001-163. That's about the funding and what happened with the dockets, where it should go, where it shouldn't go. Very importantly, the response to all of those paragraphs from the National Commissioner is as follows. He says, if you'll give me 1 second. 003-44. He says at ad para 170 to 174, he says, he gives at 32.1 the generic denial, and on the specific question he says, when an information note was asking for financial assistance for the investigation costs, I made it clear that the dockets should be returned to the stations of origin. So what that means for the stations of origin is that it must go back to KZN. And so General Mkhwanazi in the replying affidavit says, I admit the allegation. Sorry, General Sibiya in the replying affidavit says, I admit the allegation. This is at 004-55. He says, I admit the allegations in this paragraph. I have explained that Lieutenant General Mkhwanazi refused to allow the dockets back into KZN. The National Commissioner does not dispute this fact. And he doesn't, because what he says is, the National Commissioner says at 003-43, I gave the instruction that they go back to the station of origin, and Sibiya in the founding affidavit and the replying affidavit tells you that's what I tried to do, but Mkhwanazi prevented that from happening. Whilst I'm there and about the dockets, can I just give you another reference to 003-70? That's from Annexure FM7, if I'm not mistaken. That comes from the answering affidavit. On the last page of that document, you can see what it says. Well, firstly, what it says, when you look at the top of the document, is it says request for funding, investigation of political killings by members, and then it says murder and robbery division, detective and forensic services. Under that it says National Commissioner approves, and if you look at the bottom, towards the bottom half of the page, you'll see General Sibiya's signature, and immediately under General Sibiya's signature you'll see General Masemola, and General Masemola says, we can't spend double on the same function. Political killings team is there already doing the function. Remember, they are in KZN. They're doing the function. Why are the dockets at HQ? It was agreed that some dockets from the team be returned to station of origin. Well, exactly. And just whilst we're on that page, look at the date of that comment. The date of that comment is the 22nd of July, 2025. We know at that stage that General Sibiya was already at home because SS1 and SS2 are dated 14 July, 2022. So on the question of the dockets and what actually happened, that's the version from the papers, Justice Davis. And what that version, with all due respect, demonstrates is it demonstrates, apart from the fact that there's this contest between General Masemola and General Sibiya and the degree of complicity of one or the other as it impacts their independence, it also shows that on the version in front of the court, General Sibiya was trying to give effect to what General Masemola wanted, and that is to let the dockets go back to KZN. That's what the pleaded version tells you. So with all due respect, to the extent that that docket issue features as a serious allegation of misconduct or whatever the case is, on the papers in front of you, you have to ask yourself, why is that even the case in circumstances when the person being disciplined seems to be complying with the instruction that they were given? But again, I don't think we have to go that far, because that's taking us down the line of the merits. Instead, what we have to contain ourselves with here is the lawfulness question under prayer 2. You've heard me on that. And what I've just submitted to you, how it relates to the interdict and the suspension relief. That's prayers 3 and 4. That's why we tell you that that's not appropriate to go ahead. Lastly, on the issue of costs, may I just make the reference to BioWatch itself? What you will know from BioWatch, and now I'm reading from 014-79, at para 25, is that it says, having regard to affordable medicines, the issues must be genuine and substantive, truly raise constitutional considerations relevant to the adjudication. With all due respect, no one can suggest that we haven't been in that realm, because we're testing lawfulness and powers of disciplinary action. The converse is also true. This would not only be of assistance, and there's another reference in affordable medicines where in this particular judgment, try and find it please, is that where in this judgment they say that the exemption to the BioWatch protection is where the litigation itself is frivolous and vexatious and has the effect of being frivolous and vexatious. And with all due respect, we'd say that we're not in that territory at all. Even if General Masemola is wrong regarding the lawfulness arguments and the interdict and the interdict and the suspension, there's no suggestion, even from my learned friend, that this has been frivolous or vexatious.
Well, your client makes far-reaching accusation. In paragraph 11 of the founding affidavit, for example, he says the National Commissioner's decision constitutes an unlawful, not action as you know argue, usurpation of the powers and the functions. It's a deliberate subversion of the Commission and the President.
Yes?
Well,
how's that frivolous or vexatious, with all due respect? In unlawfulness type of contests all the time, allegations of unlawfulness are made by one party against the other.
no, sure. That's the point.
Exactly.
It goes further. I said if it stays there with unlawfulness, that's one argument. So once you start accusing someone of a deliberate subversion of the President without evidence that this is what the General did.
No, with all due respect, that's the very purpose of prayers 3 and 4. One of the concluding arguments about the intersection between General Masemola's powers and the Commission's powers is what's the consequence of that?
But the allegation, the evidence which you put forward...
But that's the facta probanda necessary to try and obtain the relief from the court. That's a conclusion that the court has that the litigant is making in front of the court. And even if that...
The Commissioner deliberately attempted to subvert the President.
That's what it says. But even if that is what it says, and that's open to some sort of sanction, that bar in BioWatch, having regard to affordable medicines, is not do you say one or two things in an affidavit that may cause a wrinkle. It's about frivolousness and vexatiousness, which is about the cause of action. And with all due respect, even if I accept Justice Davis's criticism of what is said in the affidavit, that doesn't elevate it to a frivolous or vexatious piece of litigation in terms of what the cause of action is trying to achieve, having regard to the prayers and the notice of motion. May I take an instruction?
The consequence of BioWatch is then every party pays its own costs.
If I am successful, if General Sibiya is successful, then costs with me. If you're not successful, then we are immunized from a cost order. Yes. Thank you. May I take an instruction? It's from the contract. It's one of our annexes. Oh, I've got it. Never mind. Justice Moshawana, just one reference, please. In respect to my learned friend, you said that we didn't argue it quite forcefully about the contract. It's obviously one of the pleaded reasons that we rely upon, And what I would refer the court to is 001-72 and 001-73, where at the bottom of that page, it says that appointment is 1.1, employer hereby appoints the employee agrees and accepts the appointment, the employee's employment and conditions of service shall be governed by the South African Police Service Act, and then over the page, the regulations, any relevant collective agreement or other legal provisions applicable to the employee. And we'd say that that reference to regulation there must ipso facto be the disciplinary regulations, because that's the only thing which regulates terms of employment as referenced in the contract. So even though we didn't push at it in opening, we nonetheless hold on to it in reply, and we don't abandon it.
So in other words, if we are with you on that breach of contract allegation, the remedy that we will be entitled to would be contractual remedy. For instance, specific discretionary in nature, or alternatively damage.
Yes, well, but remember, with all due respect, and I just want to find my papers, the issue of specific performance and the issue of damages, may I read a judgment to you, if I can, which answers your lordship directly. It's the matter of Letsho Lonyane versus Minister of Human Settlements and another, 2023, ZALCJHB, so the Johannesburg Labour Court. Yes, I would imagine so. And what the judgment says is that the matter before me is one of an alleged breach of contract. The applicant does not seek the remedy provided for in the LRA, that's the territory in which we are in. It goes on to say, having regard to a judgment of Lechranzi J, that an order of specific performance for a material breach of contract is a remedy available to a party to a contract who is not obliged to simply sue for damages. So insofar as the two options are concerned, the option is available to my client to elect whether it wants specific performance or damages, because remember, in terms of the judgment, he's not compelled to sue for damages. And then it goes on to say, and admittedly this case was in the context of unlawful termination of employment, but we say that the logic nonetheless applies here in the context of what we say is an unlawful suspension. It says, when applied to an unlawful termination of employment, it requires the restoration of the actual employment relationship to what it was prior to the breach. The value of this remedy is naturally diluted if it is not sought as a matter of urgency. And we say that that's exactly the territory we are in. The timely availability of an order for specific performance as a remedy cannot be equated except superficially to the reinstatement under the LRA. So the importance of that judgment, with all due respect, is threefold. Specific performance is available to you where you're not obliged to sue for damages. That's point number one. Point number two is that where you're in a contractual breach and you want specific performance, you must seek that remedy urgently. And in fact, that's what our orders would have the effect of doing, because that would give us the specific performance that our employment contract would be respected and to have done so urgently. And lastly, when we talk about reinstating the employment relationship, it's not the same reinstatement under the LRA, it's simply the status quo ex ante, if I may use the Latin phrase, that is restored. And so that's the 3 points we say which we're entirely on all fours with that particular judgment.
Specific performance in a contractual situation would be simply that comply with the terms of the contract. For argument, if the contract says that before I get terminated, I must be given a disciplinary hearing, or it does the specific provisions of the contract. And if the court is with you, or the specific performance is not going to be reinstated, it is going to be follow the disciplinary procedure.
Yes, I think we are ad idem, because how I understand what your lordship posits to me, and let's take your lordship's example. Let's say I was terminated before I was given the DC, and then the remedy that is sought is not the damages claim, the remedy sought is the specific performance, in other words, comply with the terms of the contract. Now, practically, legally, the difficulty I might face is that if I don't pray in aid of the court setting aside what is otherwise an unlawful termination, then my specific performance remedy might be rendered moot. So adopting your Lordship's logic and applying it to these circumstances, the reason I have to attack under prayer 2 the stay-at-home order is because I'm saying that's the unlawful consequence of not complying with the contract. And then when I get through the stay-at-home order and I pray for specific performance as a consequence of follow the correct procedure, which is also then amplified by 3 and 4, then I think we're at Eden.
Whether we are at Eden is another.
Well, I'm characterizing myself as being at Eden with you, my Lord. Whether you find that is entirely different. My learned junior, Mr. Sangoni, says that the status quo ex ante must be restored, and that's indeed so. May I just take one last instruction, please? I'm very indebted, my Lady Presiding, members of the court, to the court staff, and to all concerned. Thank you. Those are our submissions for the applicant.